Okay, we're now going to turn our attention to the acquisition of property and how it is that people generally acquire property. We'll talk about the different methods, but then we're going to focus on the sale of property from one party to another and the issues that are involved with that, and we'll talk about how it's done and the steps that are in that process. But we'll start with the different ways that people acquire property. The first is inheritance. Somebody dies, and upon their death, they transfer property to their heirs. Okay, family, not family, it doesn't really matter. But one party is given ownership as part of the settlement of the estate of the person who died. Another way, and we'll talk about this a little bit later, is adverse possession. And in adverse possession, what happens is you kind of end up getting property that isn't really yours, but we'll talk about that a little bit later. We then have eminent domain, and this is a concept under which the government takes ownership of private property through a forced sale, when essentially the government says, we need this land for the common good, and we're going to buy it from you. And the fourth method is a sale. And this is two different parties agree on the transfer of the ownership of the property, some consideration being given. Now, most sales take place in a two-step process, and this is what it is that we're going to look at. The first step is there's a contract. Okay, we'll talk about the contract. And the second step, the deed to the land is exchanged for the consideration. Okay, so we've really got the contract is written, drawn up, and then we're going to have the deed that's going to transfer as well. So looking at the contract first, we know that this contract for real property has to be in writing. We've seen that many times. We know that that's part of the statute of frauds. So it needs to be in writing. We know that. And we know it needs to be signed by the party that the contract is trying to be enforced against. Okay, it doesn't need to be signed by both parties. It needs to be signed by the party that we're trying to perform under this contract. It doesn't have a specific form of writing. It doesn't have a specific structure to it. So it can be an informal writing if we want to look at it that way. But there is a minimum of things that it must include. Okay, the writing, the contract itself needs to include the identification of the parties. Okay, we need to know who the people are that are part of the contract. We need to have a description of the property, and the description of the property needs to be sufficient enough to be able to identify it, so that we know exactly what property it is that is being transferred. We need to have the time of the conveyance, called the closing, when it is that the property is going to switch hands, when it's going to be transferred. We need to know what type of deed is being given. Okay, we'll talk about this when we talk about deeds, but we need to know the type of deed. And then we also need to have the terms and conditions, which includes the price, what it is that's going to be paid, and also the manner of payment, how it is that it's going to be paid. Okay, so we need to have a written contract that has to include at least these things. Now, occasionally or at times, courts have enforced oral agreements if it has been performed in good faith, and not enforcing it would cause one of the parties to benefit and cause the other party to lose. But for the most part, you need to know it needs to be in writing, and this is what needs to be in the contract. Now, when we're making this contract, we have somebody who's selling the property, and there is an assumption, it's implied in a sale, that the seller is providing marketable title. Okay, it means that the seller is able to sell the title, or able to sell the property. It doesn't mean that the title is perfect. Okay, and we'll talk about some of the things here about this. It's just free from reasonable and plausible objections. So it must be free from private encumbrances that are not specified in the title itself. Okay? If something is specified, written in the title, then the buyer knows about it. There's nothing wrong with that. So these encumbrances would be something like an easement, a right-of-way through the property or an access to use the property, and mortgages. Okay? So easements and mortgages we need to tell people about. That's not, if it's not already written down. Now, there's another couple of terms here that you need to be aware of, and these are zoning laws. Okay, zoning laws and what are called subdivision restrictions. And if there is something like this as a restriction on the property, it's okay. This does not hurt marketable title. You can still sell it. A zoning law is a local law that says what it is the property can be used for. For example, it might be zoned residential, in which case people can live there. It might be zoned business, in which case a business can be there. It might be zoned mixed usage, which means you can have businesses on the first floor and apartments above it, whatever the case may be. Zoning laws are okay. A subdivision restriction is when we're talking about the building of a subdivision and property within that subdivision. There may be requirements about a house and what is built there. It needs to be a brick house. It can't be a brick house. The garage door needs to be on the side instead of the front. Those are all okay. Okay, that's not going to make it so that the person is unable to sell it. Okay, so we need to have marketable title. Now, title insurance is, as the name indicates, it covers losses that result to the buyer from a defect or a failure of title to real property. Okay, protects the buyer against any problems, in essence, that come up about the title, if there's some imperfection in the title of the property. They are not protected from those that are specifically listed on the face of the policy. Okay, not protected against what is listed, which is kind of a standard insurance thing. Okay, you're buying insurance to protect yourself against having some sort of imperfection in the title. Now, we're talking about a contract here. So we also need to talk about what happens when one of the parties breaches the contract. If the seller breaches the contract, what are the buyer's remedies? If the seller breaches the contract, the buyer can try to get specific performance, because all land is considered to be unique property. If you're buying land or some sort of real property, you can try to get that because that's what you bought. You didn't buy something else. You may ask for what is called abatement, which is a reduction of the price. Okay, they breached, something wasn't done like it was supposed to be done, and so we'll get a lower price. Or very similar to that really is damages. If you're able to show how it is that you were harmed, then you're going to get compensated for that. If the buyer breaches the contract, what can the seller do? Well, they can also try for specific performance. Okay, there was a contract. Let's perform the contract that was agreed. They can try to get damages, the difference between the contract price that they had with this buyer and what it is they had to sell to somebody else for, a lower price if they had to sell it for somebody else. They could also try to get liquidated damages, which would be keeping a down payment. If a down payment had been made, keeping that and not returning that to the client. Okay, so these are the issues that we have about the contract. The main thing about the contract is what it is that is included in the contract, the information that needs to be there. Okay, the deed. The deed is the formal document that transfers interest in land. Okay, formal document that transfers any interest in land. The grantor is the party who gives the deed, and the grantee receives the deed. Okay, the grantor gives it, and the grantee receives it. in the deed, we need to name the grantee and sufficiently describe them. Okay, so we know who it is that is going to be receiving this. Okay. We need to sufficiently describe the land so that later we can figure it out. Know what land it is that was transferred. Now, just kind of a side note to this. One of the problems about the description of land in the past was that when land was described based on geographic identification, but the tree, the river, the rock, or something like that, well, over time, these things may move. The river moves a little bit, the tree is destroyed in a fire, and so it's no longer there anymore. And so we need to make certain that the property is going to be able to be identified, okay, that we're able to determine what that is. Now, the deed generally contains a number of other clauses to it, and these are in the material. I won't write them all down, but we have a premise clause that states the parties, the purpose of the transfer, and the consideration. The granting clause describes the land. The habendum clause states that the estate states what estate it is that is being conveyed. The redendum clause gives any conditions or reservations to that. The covenants clause contains the seller's warranties. We'll talk about some of those later. And then the conclusion, that is the signatures of the parties that are involved in the contract and any witnesses that are there as well. But we just need to make certain that everybody's described and the property is described so that we're able to identify it in the future. Now, we've talked about a contract and a deed, and this is just a detail to remember in case you get this question. But the important difference between a deed and a contract is there is no requirement that the transfer of land be supported by consideration. So a deed doesn't need to contain consideration in it. Okay, it doesn't need to have consideration in a deed, but a contract does. Now, the next issue that we have is the process of transferring and recording the deed. Okay, kind of a two-step process, and this is important. And a little bit to kind of put this into a different context, what we're doing with this recording of the deed is the same thing as we were trying to do with secured transactions in terms of letting other people know that we have this claim in this land. Okay, and so it's that same kind of idea in this. The deed needs to be transferred in order to transfer the interest of the party, or of the property, okay, to the other party. You can't transfer that interest until the deed has actually been transferred. And also, when it's transferred, it has to be transferred with intent. Okay, it has to be intended to have been transferred. So you find a deed, that's not going to work. It needs to have intended to have been transferred. Now, what happens is the recipient is going to want to protect their interest in this property. And so what they're going to do is they are going to record the deed in the land records office. Okay, wherever it's going to be, in the county courthouse or whatever the case may be. And then by recording it, we're putting subsequent purchasers of the land on notice that it's already been bought. And this recording protects the purchaser from subsequent purchasers of the property. So once you've recorded it, they can't sell it to somebody else. Okay, you've already done that. Now, depending on the laws of a state, the state that we're in, there's three different ways of recording, or three different requirements. The first is what is called race notice. Okay, race notice. And what happens in race notice is that once the bona fide purchaser of the property records their interest, they are protected against any prior unrecorded interests. Okay, prior unrecorded interests they are protected against. Okay? In a notice situation, no matter who files first, any person who knows that someone else already bought a property cannot claim priority on that property. So an unrecorded claim will have value, will be enforceable only if the person who subsequently recorded knew about the unrecorded claim. Okay, so you can't claim over somebody you knew about. Okay, if you knew about it, your recording doesn't help. Can't claim over somebody you knew about. Okay? The third status, or the third type, is what is called race. And in this situation, any unrecorded deed is not valid against any prior recorded deed. So the first party to record has the best claim. Okay? So it's a race to see who can do it first. Again, don't get lost in the details. There's 3 different ways that this can be done. It depends on the state. Okay? So it's just something to be aware of. Now there's also different types of deeds, and the different types of deeds have kind of different support to them. Some are better than others. And so the 3 types of deeds that we're going to look at, we look at a general warranty deed, we're going to look at a special warranty deed, and we're going to look at a quitclaim deed. Okay, these are the 3 that we're going to look at. A general warranty deed is the type that transfers the greatest protection to the recipient. Okay, the greatest protection to the recipient. And what's happening is this deed, this general warranty deed, is going to transfer all 5 of what are called the covenants of title. And it guarantees that the title is good against all encumbrances arising prior to the transfer. Okay, so what we need are the 5 covenants. And again, this is simply going to be a list that you need to memorize as to what they all are. The first is what is called the covenant of cession. And I hope I'm pronouncing that correctly. The grantor guarantees that they own the property and they have a right to transfer it. Okay? The person says, this is mine, I have the right to transfer it. We have the covenant of quiet enjoyment, which sounds very nice. And what this means is that the person who receives it will not be disturbed in their enjoyment of the property by either the grantor or a third party's lawful claim to the property. So once you get it, it's yours. Nobody's going to bother you about it. There is a covenant against encumbrances. Okay, the covenant against encumbrances. The grantor, the person giving the deed, guarantees that there are no existing encumbrances against the property. They guarantee that there are no defects either from the time that they owned the property or before they owned the property. Okay, so let's put this here. No defects from before they owned it. Okay. The 4th covenant is the covenant of further assistance. And what further assistance does is it guarantees that the grantor will execute or obtain whatever documents or assurances are necessary to perfect the title. Okay, they're going to do what they need to do. And then finally we have the covenant of warranty forever. Of warranty forever, the grantor will forever warrant the title to the property. Okay, the person who gives it. So, general warranty deed has in it the 5 covenants. If you are buying property, this is what you want. Okay, this is what you want. In a special warranty deed, all of the 5 covenants exist. They're all there, but the warranty to defects is only during the time period the grantor, the person who's giving the title or the deed, owned the property. So there is no guarantee about the time before this owner owned the property. Okay, no guarantee about that time before. So that's the difference between a general warranty deed and a special warranty deed, is that the time prior to this current owner, okay, the guarantee that is there. The third type of deed is a quitclaim deed. This is the least protection being given to the buyer. If you are a buyer, you don't want this. This is pay less for this. It transfers all of the grantor's interest in the land and nothing more, and makes no warranties in respect to the title or anything else. So this transfers their interest in the land, and that's it. No guarantee. You're going to buy it and somebody's going to show up tomorrow and tell you whatever. Okay? So quitclaim deed has the least amount of protection to the buyer. Okay, title by adverse possession. I mentioned this as one of the ways that you can obtain property or acquire property. And this is something that I can't see it happening a lot because of what it is that is required for this to happen. But basically, there's a mechanism for you to obtain property that doesn't belong to you by providing proof of a long-continued possession of the property. Okay, different states are going to do it differently, but usually it's about 20 years. So, if you've got property, or if you're using property that is not yours, and you use it openly, you're not hiding it, you're not trying to make it in secret or something like that, and you're letting the real owner of the property know that you're using the property, and you use it continuously and exclusively, and you hold yourself out as the owner of this property. If the other person who really owns the property doesn't object and doesn't tell you that you're not using the property or you're not going to get to keep the property, you get the property after 20 years. Okay. Now, if you look at this, I can see that conceptually this exists. But again, the fact that you have to do it openly, continuously, and the other person is not going to object to it, you get the property. But probably the person's going to object to it when they see you're using their property. They're going to say, I'm sorry, but this is my property. Okay, maybe you can use it, but I'm not giving you the title to the property. You're not taking ownership of it. I'm letting you use it. Renting it even if they want to charge you for it. Okay, so it exists, it's possible, but again, it's not something that you need to worry a great deal about. Okay, a few questions here. Dash has agreed to sell a warehouse for $300,000 to Bosch. The contract provided that Dash will convey to Bosch whatever interest Dash may have in the warehouse. Under the terms of the contract, Bosch is entitled to receive, well, whatever interest Dash has in the warehouse. That is a quitclaim deed. They get whatever it is that Dash has in the warehouse. Who knows what that is, but whatever it is, that's what the transfer is for. Okay, the second question, for a deed to be effective between a purchaser and a seller of real estate, one of the conditions is that the deed must, A, be recorded within the permissible statutory time limits, B, be delivered by the seller with intent to transfer title, C, contain the actual sales price, or D, contain the signatures of the seller and the purchaser. Remember, this isn't about the contract. This is about the deed. And the deed needs to be delivered, and it needs to be intentionally delivered. The delivery had to be with the intent of transferring title. And so that's what needs to be in the deed. So what we've talked about here is how we acquire land, largely through the sale. You need to be aware of the requirements of the contract. You need to be aware of what the deed is and the different types of deeds and the guarantees that are given with the transfer of that.